just joined. It has just turned 12. We will just wait for a few more minutes because there are lots of people joining. So we'll just wait for a few more minutes before we start. Thank you. Sorry, good morning, everybody. I've just been asked a question about why they can't see any other participants. We are using a webinar program, so for GDPR purposes, all participants signing on, you cannot see anybody else that's joining this, and they cannot see you or your details. You can only see myself as the host and Barbara, who will be speaking. So that's the reason why you can't see any other participants, because we are using not the normal Zoom program, but the Zoom webinar program. Okay, good afternoon, everybody, and welcome to the 5 Stone Buildings webinar program. I'm going to hand over to Barbara Rich, who's speaking today. Barbara?
Hello, everybody. I hope everyone can hear me, and welcome to this webinar. I'm sorry that, as Joe's just explained, for GDPR purposes, you can't all see each other, which unfortunately robs us all of one of the pleasures of a face-to-face talk, which is the chance to catch up with colleagues, to meet new people, and in this virtual setting, obviously to check out each other's home decor, pets wandering in, and so on. So I'm sorry you've been deprived of that. I just want to start, before we get stuck into will formalities and briefly go back to the 1780s, just want to mention a few housekeeping things. At the bottom of the screen, there's a Q&A box, and if you have any questions, please do type them in, but I'll take them at the end rather than as they crop up, because if for no other reason, my multitasking skills aren't really up to that at all. The webinar is being recorded. If you don't want to be identified, please feel free to ask a question anonymously, which you can do by ticking a box, and I won't identify you in my reply. And once the recording's complete and edited, we will post a link to it, on our website and on our Chamber's Twitter feed. And we recommend that you view the webinar in speaker view, but obviously how you view it's entirely up to you. And if there are any outstanding questions, of course, please don't hesitate to contact me. I will also be updating my blog with bringing things up to date. So that's enough housekeeping. Let's get stuck in. Now, in a way, this could be an extremely short talk, consisting simply of the proposition that the Wills Act 1837 remains in force with its familiar provisions for the execution and witnessing of wills in England and Wales, and nothing has changed. That is the gist of it, but of course there is more to say than that. What I'm going to do is just sort of set the background and then go through such developments as there have been over the last 10 or 11 weeks that we've been living in this unusual crisis, which has affected all of our lives in a multitude of ways. So people professionally interested in the execution of wills, who perhaps last encountered the case of Casson and Dade at law school, have been giving it a certain amount of scrutiny in the last few weeks. And that's the case. It involves a woman called Honora Jenkins, she was relatively unusual for her time because she was a married woman. In fact, she was a widow at the date she made her will. But for the 1780s, for a woman to have, particularly a woman who had been married, to have power of disposition over property was relatively unusual. And in fact, it wasn't her husband who'd left her wealth, but her father, and he was descended from a family of Yorkshire grocers, which had, as prosperous rising families tend to do, it had reached the aristocracy just after the Civil War, had produced requisite quota of mad uncles and other saner members of the family. And Honora made her will in York in the 1770s, and it was subsequently the subject of a very short probate case. And the interest in it is that she and her witnesses were not sitting at the same table, as it were, when the will was executed. But the evidence was that being asthmatical, and that's got a certain poignant resonance for today, being asthmatical and the office very hot, she retired to her carriage. She'd come driven in a horse and carriage outside her attorney's office. She retired to her carriage to execute the will. The witnesses attending her, after seeing the execution, that's her own signature of the will, the witnesses returned into the office to attest it, and the carriage was put back to the window of the office. The horse reared, apparently, and so she could see through the window the witnesses attesting her will. She might see what passed immediately after the attestation. The witnesses took the will to her. One of them delivered it to her, telling her they'd attested it. She folded it up and put it into her pocket, which was not a pocket as we know it, but a sort of primitive handbag. But ever since that case was heard in the early 1780s, it's been authority of the proposition that what the Wills Act, which was subsequently enacted, what the Wills Act requires in Section 9 is visual presence, and there are other cases which say the same sort of thing, that there must be a sight line between the testator and the attesting witnesses. So how can that be reconciled with the requirements of public health regulation which has changed and is going to continue to change over the period in which coronavirus is circulating in the UK. And it's been widely reported that the recognition of the mortality rate and the confrontation with one's own mortality that's prompted by the way in which coronavirus has dominated the news has prompted a very large number of people to make or update their wills. Solicitors involved in the execution of wills were designated key workers right at the start of the pandemic and have been extremely busy. And the primary question is, does Section 9 of the Wills Act enable sufficient social distancing for the purposes of public health? And I know, both anecdotally and from news reports, that many solicitors have, as it were, brought Casson and Dade up to date, brought Honora Jenkins up to date, and there have been witnesses standing in gardens, in driveways, over car bonnets, and so the formalities have been observed without too much difficulty. Of course, it has been lovely warm spring weather, which no doubt facilitated that. It isn't an answer for people who are in absolute isolation, for example, those who are ill and in inpatient treatment or ICU treatment and who can't have visitors, and for people in care homes who have not been able to have visitors. There hasn't been a solution there. And in the background to all of the debate that's gone on about whether there should be emergency legislation to relax the requirements of Section 9 is the work that the Law Commission did in 2017. They did a very comprehensive report. Some of you may have been consultees or attended. I certainly went to at least one of the kind of roadshows that the Law Commission did to discuss their consultation materials whilst it was still work in progress. And that's an important part of the background, because it's likely that if there is any legislative change in England, it is going to be certainly going to have regard to what the Law Commission thought might or might not work by way of reform of the formalities. And of course, when the Law Commission did this work, nobody, well, it's perhaps not quite true to say nobody, because I know that people clinically engaged in work on infectious diseases and research into emerging infectious diseases have been predicting a pandemic, of a respiratory virus pandemic for a long time. But nobody in the world of wills and the legal profession necessarily foresaw, at the time the Law Commission was doing its work in 2017, that there would be a degree of urgent focus on this particular aspect of it, driven by the emergence of a highly infectious disease with a significant mortality rate. And what happened was that, having done a very comprehensive report, the Law Commission, rather than proceed straight to a draft bill and looking for time, what was in any event a rather fraught and busy legislative programme, said, well, we're putting this on one side for the moment because we've been asked to look at the law of marriage, and that is taking precedence at the moment. So the Law Commission report is there to very much inform the background, but that's the reason why it hasn't been in the foreground in the short period since it was completed in 2017. And of course, formalities and witnessing was one of the areas they looked at very closely. And they said that they wanted making a will to be simple and accessible. And their provisional proposals included introducing something which would be novel in England, but already exists in a number of common law jurisdictions around the world, which is the dispensing power. And I'll say a bit more about that later on, but essentially it's the power for a court, it has to be exercised judicially, to admit to probate some material, I'm deliberately not calling it a document, but some material which expresses wishes for what should happen to a person's property after their death. And the key quality that the judge has to find that it has in order to exercise the dispensing power is intention, that whatever the material is should be a will. So the Law Commission favoured the introduction of a dispensing power in England, and as I say, there are a number in other English-speaking jurisdictions. So there's quite fertile ground for looking at the structure and the operation of those sorts of powers. And one of the most striking examples, which is actually quite widely reported here, as it happens, also in 2017, around the time the Law Commission's report came out, was a case called Nicol, decided in Queensland in Australia, where a man on the verge of suicide, and clearly he was a man who'd struggled with his mental health for some time, he left an unsent text message on his phone that was found after his death. And that unsent text message was admitted to probate, surprising as that might seem, in the exercise of that dispensing power. So that's an example of just how far its reach might be. And the Law Commission looked at electronic signatures, technology and so on, but without reaching any firm positive conclusions on those. They recognised the possibility of change, so that they foresaw that legislation might update Section 9, might remove the requirement for physical visual presence of testator and two witnesses, but they didn't formulate a preferred vehicle for doing so. The dispensing power is really the most striking element in what they favoured. Since we have lived under emergency legislation, since the pandemic came to the UK in March, there have been and continue to be high-level discussions between the Ministry of Justice and the Law Society Wills and Equity Committee, and it's Ian Bond, who's the chair of that committee, has been, obviously a lot of the content of those discussions is confidential, but he's been quite communicative in the public sphere about progress and has written about it in various places. And he has said that amongst the things that are being discussed with the Ministry of Justice are the introduction of a dispensing power, or possibly changes to Section 9, possibly even Section 15, which is the section that prohibits a beneficiary or beneficiary's spouse from witnessing a will, possibly the recognition of holograph handwritten wills without witnesses, which is favoured in some European legal systems, but that wasn't favoured by the Law Commission. So that is how things were at the end of March. And since then, those discussions have continued. And in a sense, a great deal has happened, but also nothing has happened because there has been no change to legislation, and there is not even a draft text awaiting parliamentary attention now that Parliament's back from recess, or even, I can't see any enabling powers in the Coronavirus Act itself. It's not obvious how the mechanics of any legislative change would be managed and where it would find a place in the parliamentary timetable. There doesn't seem to be any handy primary legislation sitting around under which some delegated legislation could quickly be made by a minister. So there is also, quite apart from content of any legislation, there's a question of process and available time as well. When I first started to think and write about this topic in late March, the Coronavirus Act and the first now multiply amended regulations had really just come into force. And at that date, to put it into context, 29th of March, in the UK, there were 17,000 confirmed cases of COVID-19 and just over 1,000 deaths. That's from the World Health Organization daily situation reports. Yesterday, those figures from 17,000 confirmed cases are at 279,800 and just under 40,000 deaths. So that's a real marker of the impact of this terrible disease on the population of this country. And inevitably, the outbreak and the rapid spread and its natural prominence has dominated the news, dominated public consciousness, has been that sharp reminder of mortality that I referred to, and has led to the work pressures on, no doubt, many of you who are active in taking instructions for wills. And as I mentioned, I know both anecdotally and from newspaper accounts that many of those instructions have been satisfactorily completed by being creative with the available setting and the available people, so as not to jeopardize, not to infringe regulations on meeting and gathering, not to jeopardize anyone's health, but to unequivocally comply with Section 9 of the Wills Act. And it's really all rather a sort of modern updating of Casson and Dade. You just have to substitute a car for the carriage outside the attorney's office. It's the car in the driveway. And quite recently, it's been reported in the professional press and also in an article in the Times Law section that Royds Withy King, and I know Amanda Noyce, who is mentioned in some of these articles, Royds arranged for a will made by a testator who was in very poor health to be remotely witnessed via a WhatsApp video link. And I'm quoting from Amanda in an article that appeared last week. She said, "We were able to check that the testator was alone in the room to ensure he was not being coerced, and then recorded his wishes. A draft will was emailed to him. The signing of the will was witnessed by his solicitor via a second WhatsApp video call, and the solicitor's wife. Both the solicitor and his wife signed the will as witnesses. Now, the Law Commission said in 2017 that that sort of remote witnessing was unlikely to be compliant with Section 9. They didn't express a definitive view on it. And in this country, there has been no test case following the death of somebody who's made a will like that, nor have we any experience of seeking a declaratory judgment in a testator's lifetime. In Ontario, somebody was gearing up to do that, and then they passed emergency legislation, and the application didn't proceed because it wasn't necessary any longer. Now, obviously, I knowing Amanda, and it's also quite apparent from more careful reports in the press, that this was done with the testator being fully advised of the risks of invalidity, being advised that in the event he survived, that restrictions on gathering were relaxed, that he should re-execute the will in conventional fashion. And I would just say more generally, obviously adopting an approach like that is likely to very much depend on what you, the professional, but also what the testator knows of those who might challenge the validity of the will. Because of course, where the only people who are adversely affected by a new will are adults of full capacity, there's a reasonable, obviously every family, every set of relationships is different, but where you have adults of full capacity, there's at least a starting point of a reasonable prospect that they may between them agree. There are no legal obstacles to them agreeing between them to seek probate of an earlier will or on the basis of intestacy, but with an agreed variation to give effect to the wish. It's really a question of how far those adults are willing to respect the informally in an emergency expressed wishes of somebody who they knew. Where it's more difficult is where you have children, adults who don't have mental capacity, and institutional beneficiaries, particularly charities. They don't have the same freedom to give up what might be a potential contentious probate claim as adults of full capacity do. So that's obviously a thing to bear in mind. And another thing that inevitably as professionals, we can only act on instructions or perhaps to try and inform people in the community of the services that we offer. What is very striking is how widespread public ignorance about what constitutes a valid will is. And I feel that those of us who deal more with the disputes side of will making are likely to see some homemade, thoroughly defective emergency attempts to make wills on our desks in a few months' time. And I'm just going to read some things. These are responses to a question posted on social media. Somebody said, I've been wondering about wills. I made mine years ago, but would like to change something. I can't get two people to witness it now. Does lockdown count as wartime? So whatever I write will be valid, like soldiers on a battlefield. Now, we all know the answer to that is no. Or if you're Gina Miller, who I'll come to in a moment, the answer to that is no, but I personally am pestering Robert Buckland to make it yes. But amongst the inaccurate answers that were given to this question, somebody said, you can type it out, sign it on webcam, photo it on your phone, send it to them via email, and take photo and then send back. Video the process if you can. Well, it's all very well-meaning, but it isn't valid. Somebody else said, I don't know, but maybe do a video of you reading it, stating the date and time of the usual language. I should do the same. Somebody said, it should be witnessed, but a statement of wishes will have some legal validity. No, it doesn't. If it's for medical care, send a copy to your GP or other welfare professional involved. If it is for stuff after death, then keep in your home or send to lawyer. Can make a new will online though. So this is just a variety of popular misconceptions. It's important to be aware of. And as I already mentioned, despite, I think these popular misconceptions, they are wrong, but it's quite easy to understand why people think they might be right and why they've been prompted, like the original questioner, to think about wills, because there's nothing in although the Coronavirus Act itself is very wide-ranging, covers a large number of topics, and in fact the regulations weren't made under the Act but under existing public health legislation. As far as I can see, there's nothing in the Coronavirus Act to enable will legislation, and there has been no other new legislation at all. And indeed, one of the background factors that's shaping the discussions between the MOJ and the Law Society is that, given the work that the Law Commission did, you're looking at quite a significant piece of primary legislation to bring into permanent effect the sort of changes across the board that they were discussing. So that's clearly not a practical proposition at the moment, and the question is likely to be a more narrow one. Is there some limited emergency measure that should be put into force now? And we get some indication of the way the Minister of Justice is thinking, because on the 21st of April, Alex Chalk, who is Parliamentary Undersecretary of State at the MOJ, had to answer a written question from the MP for Brighton Kent Town. The question was to ask the Secretary of State what assessment he's made of the implications of social distancing for the requirement in the Wills Act 1837 that a person who may be a vulnerable individual be in the physical presence of two independent witnesses. Will he enable A, video conferencing, and B, privileged wills, he means as in military wills, in those cases during the COVID-19 outbreak? And what the Undersecretary said in response was that the government is currently reviewing the case for reform of the law on making wills given current circumstances. The constraints of the COVID-19 situation must be balanced against the important safeguards in the law to protect elderly and vulnerable people, in particular against undue influence and fraud. Having two independent witnesses provides safeguards to those making wills. Privileged wills are a long-established convention restricted to people making wills when on active military service, where the normal formalities cannot be observed, but which do not equate to the current civil circumstances. Other reform measures are being considered at present. And in the longer term, the government will consider reforms to the law on wills arising from the Law Commission report, which will explore a range of issues, reviewing the current law and the case for reform, including on the use of technology. The government is committed to considering further work on witnessing documents by video conference generally. So that is the most authoritative ministerial statement of where we are, and this was made in late April. Excuse me. In the meantime, other jurisdictions have put some legislation into effect, and just a very brief around the world tour of some of them. In Scotland, the Law Society of Scotland has temporarily amended its guidance on witnessing to allow a lawyer to witness a will via video conference, provided the lawyer isn't also appointed the executor, so take out that kind of conflict of interest. In Ontario, in early April, they passed an emergency order authorising remote witnessing of wills. In New Zealand, again in mid-April, they brought in emergency legislation permitting a testator to direct another person to sign on his or her behalf remotely, and also to permit remote witnessing in circumstances where an epidemic notice, which is part of the New Zealand legislative apparatus for dealing with coronavirus, is in force. And the sort of anti-fraud provisions built into that legislation were whoever was doing the remote signing or witnessing had to make a declaration on the face of the document to that effect, and also photograph the relevant documents and circulate them, so there's a kind of immediate contemporary record. In Queensland, this is temporary legislation operating between the 1st of March and 30th of September this year, again in late April. They introduced a judicial process to dispense with the requirement for witnesses to be in the physical presence of the person making the will. And that Queensland already has a dispensing power, but this is perhaps a more streamlined, it's still a judicial process, but it looks as if it could be streamlined if there's evidence that the will was drafted by a solicitor, so there's a requirement for professional involvement, or a solicitor is one of the witnesses, or is the person supervising the execution of the will. The deceased intended the documents to take immediate effect as their will, or alterations or revocation, that it was executed in the presence of two witnesses, but that doesn't mean physical presence. It could be done by way of video conference, and the witness is able to identify the document executed. And the reason it's not a general dispensation, the reason why it wasn't done physically in the presence of two witnesses is either because of government enforced or recommended or self-imposed isolation or quarantine arising from the pandemic. And in New York, again, this is New York State, temporary legislation renewed month by month, authorising witnessing by audiovisual technology. And again, similar sort of ancillary compliance measures to stop people just fabricating the entire thing. And one of the things that I have to say slightly amused me, the New York Times ran an article in late April about what was going on in England. Their London correspondent described a sort of typically North London scene of people handing over bottles of wine in return for having something witnessed on in their garden. And New York Times always seems to enjoy portraying England as a slightly backward and quaint place, and it referred to an archaic law. That's our section 9. Coyly not mentioning until quite a lot further down the article, and indeed only mentioning my reference, that archaic law is subject to the temporary amendment, precisely the same in New York State. And something else I have to say I derived wry amusement from is, I don't think the New York Times is in the strongest place to portray England as a place of archaic law. When you look at the New York State law, which provides that the witnesses must receive a legible copy of the signature pages, which may be transmitted by fax or electronic means. By fax is extraordinarily archaic. So I think there's a certain amount of glass houses and stones there. But what's interesting is to see, obviously there are detailed differences between these various legislatures, but their broad similarity is to start from the assumption that Section 9 or its local equivalent requires physical presence, as in an Nora Jenkins case, and to relax that by permitting video witnessing or video signature at the testator's direction, with a range of compliance safeguards to stop that process being abused. Again, another development which is very much self-isolated in its own bubble is that the well-known campaigner Gina Miller, who was responsible for the Miller 1 and Miller 2 cases in the Supreme Court, has launched a campaign with a certain amount of attracted a certain amount of attention because she has a high profile and she's also supported by Helena Kennedy. And neither of these people have, as far as I'm aware, have shown any particular interest in the English law of wills before. And their campaign is quite narrowly focused on seeking an extension to the law of privileged wills for people on active service. And simultaneously with launching her campaign, Gina Miller's created, it's a free website which you can have a look at. It's called Messages of Love, and it's for people, perhaps frontline workers, I myself don't see the attraction of the proposition. If I have something I want to say to people close to me that they might have after my death, something's not a will, but just an expression of affection or attachment, I will make a video or get on the family WhatsApp and do it that way. So, but maybe there is some demand for this. But she is also seeking to use that, I think, as a prototype vehicle. It goes hand in hand with the campaign. If the campaign was successful, that would be the vehicle. Now, I'm quite sceptical about this because, for one thing, the Law Commission itself in 2017 thought that the two witnesses was really something important, that although it was inconvenient to have to find two, the balance came down in favour of them. It didn't favour an extension of military wills or oral wills generally. And then there's also that very clear answer from Alex Clark in Parliament saying, well, we're not actually favouring that route. We are looking at other things. And messages of love, its proposition, I'm quoting from the website, is, my thoughts drifted to the idea of a simple but secure digital memory box that harnesses technology so people can deposit messages that have the power to lessen sadness and grief, to bring comfort. Cameras on mobile phones or other devices mean that carers and coronavirus patients can leave individual messages to loved ones, record their wishes if they haven't had time to do a will, or a message of wishes in respect of children or their treasured possessions. I don't think that's very helpful to suggest that it might be possible to use this digital memory box to make a will. And there was some discussion on Twitter between me and Brian Sloan at Cambridge University, who's very interested in the law and teaches and researches the law of succession. And following that, the Messages of Love website now has a prominent note saying, oral wills are currently not legally binding in the UK. We are campaigning for this to change, as we believe the government has the power to bring in emergency provisions under the Coronavirus Act 2020, where we still believe it's better to express your wishes to loved ones rather than leave nothing at all. Now, as Brian Sloan himself has written, there are a lot of problems with oral wills. Testamentary intention may be doubtful, and particularly I would say if the vehicle for recording your supposed oral will is a general Messages of Love website, which also includes messages that aren't intended to be wills. And it's also quite unclear from what has been said in public about this campaign. It isn't, and I think this is one of the problems of somebody who is a campaigner seizing on an issue to campaign about in entire detachment from the work that's been done by the Law Commission, and the Law Commission's consultation reflects an enormously wide range of informed views from people in the professions, people who deal and have dealt with wills for years and have given more thought to the various interests that have been balanced. This isn't a question of a draconian law oppressing the people. The law protects testators. That doesn't mean it can't be reviewed or updated, but there's a more subtle balance to it than I think this campaign recognises. I also think there are structural weaknesses in the proposed vehicle, because the idea is that whoever leaves a message in the digital memory box appoints a nominee who will be notified of the existence of the message and have access to it after the person's death. Well, a nominee isn't an executor, and an executor has important duties and can be called to account even if an executor just adopts an ostrich posture and doesn't disclaim but doesn't apply for probate. There's a remedy for that. There's nothing that can be done about a nominee. And the Messages of Love website itself belongs to a small private company of which Gina Miller is the only shareholder and director. Well, it's very generous of her to use her property to provide a service to the public. But what happens if that company just disappears, is wound up or taken over? There's no real assurance that something as important as a will that may not be brought into effect for decades is really in a lasting, secure place. So that's where we are. Just to summarise the present position then, is that England and Wales is really increasingly becoming part of the exception rather than the rule in not having done any temporary relaxation of will execution formalities, nor do we have an enacted dispensing power. And although happily at present new cases of coronavirus and mortality is falling pretty sharply. It's fallen there's very little in London at the moment. I know the regional picture varies quite widely. Clearly coming towards the end of a first peak. Whether there are further peaks, obviously way beyond my whatever educated insight I have, it is not into epidemics and infectious diseases. So we shouldn't rule out the possibility of a change in the law, but we certainly are behind other jurisdictions which moved very quickly in April to bring in the sort of changes that I've delineated. And we don't know what form that change might take, whether it would be, it may be that given that it's favoured by the Law Commission, it may be the introduction of some form of dispensing power. That has its own disadvantages because it involves inevitably a judicial process, and a judicial process that even the streamlined one which they've introduced on a temporary basis in Queensland, that's a much higher level of scrutiny of validity, of admissibility to probate than our current non-contentious probate rules embodies. And also, as re Nicol, the text message case is a perfect example of that, it can be bitterly, bitterly adversarial and costly in small estates. And again, re Nicol, I won't go into the particular, we don't have time to go into particular facts and personalities, but the outcome of re Nicol was such that it left people who, under the relevant legislation there, and it would be the same here, were unquestionably eligible to bring Inheritance Act claims, prima facie, without reasonable provision. So you've got a rather unattractive, potentially unattractive prospect, bitterly contested litigation about intention, whether the dispensing power of the court should be exercised, potentially followed by another round of litigation of reasonable provision claims. So that is a possibility. Another might be to follow the model or something like the model of the various jurisdictions that I've referred to. Now, one thing that's struck me for some time about just summarising where we are is the contrast between what is required for the validity of a will and what's required for the validity of a lasting power of attorney. And the Office of the Public Guardian is reporting that, unsurprisingly, there have been far fewer lasting powers of attorney executed during lockdown than there usually are, because a lasting power of attorney has, in fact, more onerous requirements for document integrity, as it were, than a will does, because it requires the presence of a certificate provider. And the certificate provider in a lasting power of attorney has a much more active role of scrutiny than witnesses to a will. Witnesses to a will, when in the rare cases where they do have to give evidence, there is no requirement for them to have satisfied themselves of anything other than to be able to say they saw this testator put their signature to this will and they added their own in the circumstances that they describe. It can be the most fleeting encounter between strangers, and there are knowledge and approval cases which quite graphically demonstrate that. By contrast, the certificate provider in an LPA has to put their name to the assertion that they're satisfied that the person making the instrument had capacity to make the instrument and that they were free of undue pressure. Now that's really coming quite close to a sort of notarial requirement. It's quite striking and interesting to me that there's no suggestion that anything like that should be introduced for wills in England, and it's slightly anomalous that these two very important documents giving up control and disposition of property in circumstances of 1, death, and 2, incapacity should have such different validating regimes. I think that's enough from me. Let me go to the questions. And anonymous attendee has asked, I've seen a view floating around online that a Zoom call may qualify as being in the presence of a witness for the purpose of Section 9. Do you have a view on whether that argument could succeed? I think there's no material difference between Zoom call, particularly a Zoom call which is recorded, perhaps recorded, and of which there are screenshots showing who is participating, date and time stamped. I think there's no material difference between that and WhatsApp. Indeed, I mean, I imagine everybody has had similar experiences of watching their hair grow on Zoom, FaceTime, and WhatsApp video, and not, you know, not. Of course, there are differences between the platforms, but essentially, they're functionally doing the same thing. So I think it's the same question as in the Rhodes-Witty-King will, which was completed via WhatsApp video. Is that degree of modernisation, of updating of the visual presence in Honora Jenkins' case, is that Section 9 of the Wills Act? In Honora Jenkins' case, she's in her carriage, she looks through the glass window, she sees the witnesses in the attorney's office. That's the 1770s, didn't have any modern technology. Can you say, well, looking through a glass, which is looking at a screen, is fundamentally the same thing? I don't think it's a hopeless argument, but the risk is nobody's run it, nobody's established it. Who wants to be the test case? So I think that's the answer to that. Yes, I will circulate reference of cases. What I'm going to do is I wrote a blog about Honora Jenkins' case and sort of the sorts of questions that the Ministry of Justice and the Law Society might well be considering at the end of March. What I'm going to do is update that, and then we'll post a link to that on the website, and that will have all the cases properly referenced on it. Anonymous attendee, do you think that a will be validly executed according to current law if a testator is in a house and the witnesses are in the garden of the same house, the testator signs the will and the witnesses see the testator sign the will through a window and then enter their details and sign the will in the sight of the testator, in sight of each other? Yes, I think so. I think that is Castle and Dade, that's Honora Jenkins' case, is where there's a visual sight line, and there are other cases that say the same. Between the testator signing the will and the testator's entering, and I think the witnesses entering their details and signing it, the will would be passed to the witnesses through the letterbox, for example. Seems to me that the will will have been validly executed. I agree. I also think, I mean, in some ways it's quite hard. Well, in some ways it's easy, in some ways it's quite hard. It's been a very long 10, 11, 12 weeks, however long it is. I do know it's Friday today, but the actual number of weeks, it has been a very long period. And at the beginning, I certainly was quite gripped by anxiety, fatalism, a degree of paranoia about transmissibility of COVID infection. And I think it's now increasingly widely known that the chances of catching it by touching a piece of paper, pretty minimal, paper packaging and so on, the chance of picking up a sufficient viral load. And I don't know to what extent people have found that reflected in more recent instructions they've done, whether testators and witnesses are still very anxious not to all put their fingers over the same piece of paper simultaneously, or whether people are taking a more relaxed and phlegmatic view of that, because obviously that does make life quite a lot easier. And it's going to vary very much from person to person, because you know, one level you've got the person who has no health issues, who's basically fine, functioning. They're unlikely to be too concerned about brief proximity to other people. Say all three people are asymptomatic and generally in good health and under 70. Those people, I would have thought, are unlikely to be over anxious about any aspect of the process. It changes where you have somebody who is vulnerable or shielding, and all the definitions change every time the amendment regulations change as well. And of course, there are going to be extra precautions there. And there is still, for people who are absolutely in isolation, and those who cannot be visited, there's still a real practical problem there. And I'd be interested if anybody's come up with other solutions. I think, have I dealt with all the questions? Let me just scroll down. No, one more. Oops. In terms of acting as a certificate provider on LPA, as far as I'm concerned, there's nothing stopping you completing the section via Zoom, etc. Do you agree? I have to say, I've never thought about it before. I mean, there's nothing. Do not take my answer as legal advice, because I really haven't thought about this before. I can't think of a reason why you couldn't do that. I don't think there's, off the top of my head, I don't think there's anything there's certainly nothing in the primary legislation or in the more detailed regulations that requires physical presence. I mean, there's an order of signing, so it's important to do things in the right order. I don't know if anybody else has got any views on that. Please do type them in the box. I mean, having said that, it's interesting to note that there's been a drop in the number. Obviously, many people do take the view there has to be some sort of physical presence, and I think there's a sort of anterior question: is if you are the certificate provider, are you sure that you've satisfied yourself that the donor has capacity to make the instrument and is doing so free of undue pressure if all your contact has been remote? And it's particularly, and the capacity, I think, not quite such a problem, because you can ask all sorts of questions. And indeed, there's a base level of capacity required just to operate technology so as to be present in the virtual room. It's more the question of undue pressure. Who is out of the picture? What is going on out with the square on the screen that you can actually see? So I think that is all of the questions. I better just, let me just review the chat. Fine. Okay, well, I think all of that's been dealt with. As I say, what I will do is bring my blog up to date and publish links to it via Chamber's website, and that will contain proper references to all the cases. I should also acknowledge, I mean, I'm not the only person who has been thinking and talking and writing about these issues. It's worth looking at what Brian Sloan has to say. He's pretty up-to-date commentator on everything. Juliet Brooke at the University of Portsmouth has also written something very useful, the Society of Legal Scholars, and Charlotte John, who's a barrister at Hardwick and who's a friend of mine, she's also very much kept up to date with these issues and has written a blog about it, and I'll include references to what she's written. And I think between us, we've covered a number of aspects of this issue. And I finished with where I started, which is there's a lot to say, but in a sense, nothing to say, which is that for the time being, what we have is Section 9 and Section 15 of the Wills Act, which the requirements of which are very familiar and haven't changed. So thank you all very much for your time and attention, and I hope we can resume working as normal and meet in a face-to-face session before too long. Thanks very much. Bye.